Week 2 assignment, Research Case Study Presentation. New York Times Company vs. Sullivan. Who are the parties to the case and what facts led to their dispute? The parties of the New York Times Company vs. Sullivan were as followed. L.B. Sullivan was the police commissioner of Montgomery, Alabama, and the New York Times newspaper company. The facts that led to their dispute was that the New York Times published an advertisement that sought donations to support Martin Luther King Jr.'s civil rights campaign. The advertisement made false accusations about Montgomery police force treatment of Dr. Martin Luther King Jr. and other civil rights campaigners. Why did Sullivan feel his reputation was damaged by the New York Times publication? L.B. Sullivan felt his reputation was damaged by the New York Times publication as a police commissioner. Although they never disclosed his name, he then sued them for defamation. Sullivan said that the advertisement provided incorrect details about the actions of the police against Dr. Martin Luther King Jr. It misstated the number of times he had been arrested and the events of a student protest. What are the key elements of a defamation case? See Week 2 reading. Since Sullivan was a public official, what did he have to prove in this particular case? The key element of a defamation case is false statement of a fact that caused injury or damage to someone. In order to show actual malice, Sullivan would have had to prove that the New York Times acted recklessly, provided falsified information, and how it has impacted his livelihood. What was the U.S. Supreme Court's decision and why did it make that decision? The U.S. Supreme Court's decision awarded L.B. Sullivan $500,000 in damages. The Supreme Court then unanimously dismissed and reversed the damage award. To protect themselves from open discourse, the Supreme Court then adopted the actual malice test, which it made clear that any public official who is suing for damages had to prove the existence of actual malice with convincing clarity. Gertz vs. Welch, 1974. Who are the parties to the case? Was the petitioner a private person or a public figure? The parties of the case were Elmer Gertz, the plaintiff, who was an attorney hired by a family to sue a police officer who had part in the death of the family's son. Robert Welch was the publishing company who filed a motion for judgment for withstanding the verdict. After awarding Elmer $50,000 from publication American Opinion for defamation, the petitioner was considered a private person. What were the alleged defamatory statements about Gertz in the American Opinion article? The alleged defamatory statements about Gertz in the American Opinion article was that Gertz was a Leninist and communist fronter because he chose to represent clients who were using/suing a local law enforcement officer. He was said to be masterminding the police officer's prosecution. What was done to confirm the accuracy of the allegations against Gertz? Many of the statements made in the publication were blatantly false. The managing editor published the article without attempting to verify its truth. How do you think these allegations affected Elmer Gertz's reputation? Elmer Gertz believed that these allegations damaged his reputation as both an attorney and a citizen. Outside of being an attorney, Gertz is considered a citizen first, who went up against local law enforcement. This could affect his livelihood in so many different ways. If he ever needed law enforcement for personal issues or personal reasons, this could affect them wanting to help him, whether it be their duty or not. What would you have done differently than Robert Welch to avoid the lawsuit? I would have taken probable cause and verifying the truth to avoid the lawsuit against Elmer Gertz. What is your state's defamation law? Research your state's law using this link, State Defamation Law. If your state isn't listed, conduct an internet query. According to the defamation law, South Carolina's defamation law consists of statutes and case law. Defamation law in South Carolina may include libel, slander, false light, interference with business relations, and other torts. There was no defamation law for South Carolina listed on the link above, so therefore an internet query was completed. How can you relate what you've learned from the Sullivan and Gertz case to future work in the communications industry? In future work in the communications industry, I can relate what I've learned from the Sullivan and Gertz cases is to avoid actual malice defamation, is to have proof of anything before publishing anything, or make accusations about someone's character before making accusations about someone's character or intentions. The one thing I have learned from reading both of these cases is that you have to have an airtight facts before publicizing and publishing the unknown, because you're discrediting not only yourself, but you're making life harder for other people. And we have to look at the reputation and how it leaves somebody's livelihood after portraying that and putting that out in the open space, in the open air, for people to know what was going on throughout the cases. I've learned that you have to actually go and obtain the proof. So when it comes to cases such as this, you have an airtight alibi to know that what you did and what you completed was all in good faith and all in good standing.